the record again.
Neon Lions.
Okay. We have a problem. He came back. We received, I think, from your office, Mr. Rusat, Trinity Health documentation. Neither, and I think
That's
you were.
correct, Judge. From January 24th.
Yes. And the problem is that the medications listed here would not come back as this on our test. So something else is going on.
And if I could explain briefly, Your Honor.
Certainly.
So on the 24th, Mr. Lyons, along with his mother, went into Trinity Health because Mr. Lyons was having withdrawal syndrome because he had not consumed any controlled substance since his original consumption prior to his arrest. Whatever is in the system right now, Judge, I believe is still trace amounts from him using prior to his arraignment. And the reason why I submitted the Trinity Health form is to show that what they prescribed him were certain medications to help him control his vomiting and to help him control his withdrawals. There was also talks by his doctor to put him on Suboxone to hopefully help that transition. That hasn't been done yet, only because again he's technically under court supervision and still can't test positive for any type of controlled substance. So my argument, Judge, is that he's addressing this. I don't believe what's in the system right now has been controlled substances taken prior to him being placed on bond.
This came back Suboxone-like, right? And
I believe so, yes.
yeah. Okay. Counsel, I hear what you're saying. And all right. Sir, I'm just going to tell you need to be honest with me. Okay. Because I get what your attorney's telling me. Okay. Have you been taking Suboxone?
Last time I took something was
The
last time I took something was 2 days before my arrest, or one night before my arrest. Everything that I dropped dirty for, I've been taking the last.
Hold on a second. Here's what I'm asking you. Okay. Because the last part of what your attorney said is the part that really became curious to me. The doctors are considering putting you on Suboxone.
Right. Right.
And you had a heroin addiction or
Opiate.
what?
Opiate.
Some type of, okay.
Yeah.
So an opiate addiction. Okay. Let me just say this way to you, okay? Sounds like you've been struggling trying to get off.
Mhm.
Your mom took you, I think that's your mom back there, took you to Trinity Health, trying to alleviate some of the things.
Right.
All right. And it's a struggle, right? Right?
Right.
Sometimes when people hear that the doctor's going to put them on, but you're under court supervision, they find a way to get their hands on some things to help.
Mm-hmm.
And so what I'm asking is somehow, did you get your hands on some Suboxone somewhere?
Yes.
Yeah.
Before though. Before I was arrested. I stopped everything the night I was arrested.
Okay. All right. So what you're telling me is that from the time you were arraigned, you haven't taken Suboxone. Because basically that's what's showing up here.
Yep, that's the last time I took anything.
All right. So, counsel, just so that I'll say this. I don't know whether to believe you or not regarding when you took it. Okay. I'm just going to say this. Okay. You're fighting through it.
Right.
Right.
Okay.
And if you did do it, I'm gonna be honest with you, I probably am not necessarily gonna fault you because I just would. Okay, in this instance. So counsel, will they put him on Suboxone if the court? I mean, is the only thing that's preventing him from going on Suboxone is the court orders or?
The court order they have no contact.
Pardon?
I told the doctor I didn't even want to take it. I didn't want to take nothing of it.
Well, okay. No, I'm not gonna have you explain it. I just, okay. So you think that if you test more, right,
Mhm.
that this is gonna be out of your system?
Correct.
Okay. What I'm gonna communicate something that community corrections communicated to us, that what you may want to do is you might want to send this test out for confirmation. That kind of lets me know kind of where your levels were. All right. So you might want to pay the $30 to do that. I mean, I know you don't want to, I get you, I hear you. But I also don't want to, it seems to me, be in a position that I gotta lock you up either. Right? So balance it against that.
Right.
Okay. So are you gonna do that, you think?
Yeah, I will.
Okay, so go back over there and do that before that sample is no longer there. Send it out for confirmation. Since you're doing that for confirmation, you're represented by counsel. I'm gonna leave the 19th. We currently have him on what week? How often are you testing?
Twice a month.
2 times a month?
Yes.
All right, here's what I want. I'm gonna change that just in this interim period and then bring you back to it, okay? You follow me?
Follow.
So what I want is 1 time per week testing. We'll get to the 19th, revisit it and see where you are. We should also then have the confirmation of the test that you took today.
Okay.
Okay? All right, so I'm gonna leave everything as is that we set this morning. I'm gonna let you go. Go get that confirmation test scheduled, and then you'll be on weekly testing, and then we'll figure out like where we are on the 19th.
Thank you,
You understand?
sir.
All right, thank you. All right,
Thank you very much, John.
thank you, sir. Court calls the case, People versus Hubert Price.
Joy Gaines, Senior Assistant Public Defender, representing Mr. Price. Your Honor, I've called Mr. Price's name in the courtroom and in the hallway, and I have no response.
Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of $10,000 cash surety. That warrant will issue immediately.
Thank you.
Thank you. Court, call the case of the People versus Christopher Quinney.
Good afternoon, Your Honor. Raymond Cook for the People. Michael Gaddy, Assistant Public Defender from 20 year.
Quinney, can you state your name, please?
Mr. Christopher Quinney.
Thank you.
You
How
are
you doing?
Your Honor, we'd ask the court to set an exam.
Said set an exam.
Yes, Judge.
Discovery is complete.
Yes, Judge.
People had their witnesses available February 10th.
For best, Your Honor.
Preliminary examination in person will be set February 10th, 2026, 9 a.m. That's before Judge Garwood.
Thank you.
Bond continue. Thank you.
Thank you, Judge.
Thank you. Court calls the case, People versus Lawrence Ransom.
Good afternoon, Your Honor.
Mr. Ransom, please state your name for the record.
Lawrence Ransom.
Your Honor, we're asking for a 2-week adjournment for plea negotiation and mitigation.
You're in the- she already has one.
What happened?
She's filling them out in bulk. What is she doing?
Oh, I didn't know if his original attorney had done one or not.
February 19th, 2026, 9 a.m. Bond continued.
Thank you so much, Your Honor.
Thank you.
Because it goes.
Court calls the case, People versus Joanna Reed.
And Stephanie Pan on behalf of the plea, should be appearing by Zoom.
State your name, please.
Johanna Reed.
All right.
And Your Honor, you should have all the paperwork for a no contest plea.
I do. And the plea form indicates that the defendant will be pleading no contest to an added count 3 of disorderly person jostling. The 90-day offense. Upon her successful no contest plea to that charge, counts 1 and 2 would be dismissed. That's the court's full understanding of the agreement.
That's my understanding as well, Your Honor.
All right, ma'am, can you please raise your right hand to be sworn? You solemnly swear or affirm that testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
All right, state your name again for the record.
Johanna Reed.
All right, you can put your hand down. All right. Ma'am, it is this court's understanding that you are going to be pleading no contest to the charge of disorderly person jostling. That's a misdemeanor punishable by up to 90 days in jail, $500 fine plus court costs. Do you understand that?
Yes.
Do you understand what a no contest plea is?
Yes.
All right. 2 things about it I have to make sure that you understand. First, that it means that you're not further desirous or wanting to contest this charge. You understand that?
Mm-hmm. Yes.
Is that a yes? Okay.
Yeah.
The other thing you need to understand is that for purposes of sentencing, the court is going to treat you the same as though you had pled guilty. You understand that?
Okay.
Okay, you understand that?
Yeah.
Okay. The other thing I need to let you know is that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Washington in the 14B District Court. You understand that, ma'am?
Okay. Yes.
Okay. The basis for the no contest plea.
Potential civil liability, Your Honor.
All right. And so, ma'am, to that charge, the disorderly person, how are you going to plead?
No contest.
All right. Now, you understand that by pleading no contest, you will not have a trial of any kind.
Yes.
All right. You had given permission for somebody to sign your name after going through an advice of rights form?
Yes.
Do you have any questions regarding any of those rights?
No.
You understand that you're giving up those rights, particularly the rights under paragraph 5, which are your trial rights.
Yes.
You understand that you're giving up your right to appeal of right.
To appeal what?
To appeal of right.
Okay. Yeah.
Do you know what that means?
No.
Okay. All right. Basically, what it means is that if you, after we're done, if you don't like the fact that you have a conviction or you don't like the sentence, you don't get an automatic right to appeal that to the next higher court, that being the circuit court. You have to ask their permission as to whether or not they'll hear it, your appeal or any complaints you have.
Okay.
You understand that?
Yes.
All right. So basically, you're giving up your right to an automatic right of an appeal. You understand that?
Yes.
All right. Are you on probation?
Yes.
Okay. At the time of this offense, were you on probation to another court?
I don't know.
Okay. Counsel, do you know whether?
I'm looking now, Your Honor.
While they're looking,
I can tell you that she was sentenced on January 20th, 2026. But I don't believe, since that happened then, she wouldn't have been on probation.
she wouldn't have been on probation in
Yeah.
25. Okay.
So as far as Washtenaw cases that the PD's office is over, the answer would be no.
All right. So, Ms. Reed, let me ask you this. Were you reporting during the year 2025, last year? Were you reporting to any court?
January?
Well, no, of last year. Were you
No,
reporting to any court?
no, I don't think so.
Okay,
No, I wasn't on probation. I just started probation, like
gotcha.
last
Okay,
week.
that's what we thought. Okay, I have to make sure.
Her
I
iChat is
didn't
clear,
know
Your
the
Honor.
difference between a bond and a probation. I had to think about it.
Okay, all right, I think we got it. And you've never been to prison, is that correct?
No, no, sir.
All right. Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No,
Has anybody threatened you or coerced you in any way?
no,
You're doing this voluntarily and of your own free will?
yes,
All right. The court has been provided and has reviewed the Washtenaw County Sheriff's Office report for their case number 25-21112. Counsel, any objection to the court having reviewed that report?
Objection.
No objection, Your Honor.
All right, based upon a review of that report, court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Ma'am, I do have to advise you that if between the time I accept your plea and the time of sentencing, if you commit misconduct as defined under the Michigan court rules, you would not be entitled to withdraw your plea and the court would not be bound by any sentence evaluation or recommendation. You understand that, ma'am?
yes. So if I violate something, that means that I will not, that means that?
That means that you can't withdraw your plea, right? That's the first thing. And if there were a sentence evaluation or recommendation to the court would not be bound by that recommendation.
Okay,
Okay, you got it?
yes,
Okay. Is counsel aware of any other promises, threats, or other inducements which have led to this plea?
None, Your Honor.
All right. And have I complied with the court rule? Would it be proper to accept this defendant's plea?
The court has.
All right. Court will accept the defendant's plea to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14B probation. Sentencing in this matter will be March 5th, 2026, with 10 a.m. Yes. 10 a.m. before Judge Washington. Okay, Ms. Reed?
March 5th, 10 a.m.
Yes, ma'am, before Judge Washington.
Oh, can I have you?
Judge Washington's a great judge, ma'am. What's your concern?
I don't know.
I'm just not that scary, right?
Yeah.
Oh, don't.
In this hearing, Judge Simpson confronts a difficult truth. Addiction doesn't fit neatly into court orders. Faced with a positive test and conflicting medical records, the judge presses for honesty, not punishment. Acknowledging the struggle, he chooses accountability over incarceration, ordering confirmation testing and closer supervision instead of jail. Moments later, the courtroom shifts again. Bench warrants, plea hearings, and even laughter, showing a judge who can be firm, fair, and deeply human, all in the same session.
Don't say that. I want everybody to think I'm scary.
I mean,
Everything's okay, Ms. Reed. Our office will reach out to you before your next court date and we'll talk to you about everything, okay?
okay.
You good, Miss Reed?
Yeah.
You made her sad, Judge. I don't.
What? Okay. What are you worried about, Miss Reed?
I don't know. I just never did this court thing before.
Okay,
It's just nerve wracking.
okay. Here's. Ms. Reed, here's what I'm gonna do, okay? I'll make a call over to Judge Washington, okay? Explain at least my impression of what you're saying to me. I'll keep the case for sentencing,
Okay.
okay? Will that work for you?
Yeah.
Okay, now, when you're on probation, you might have to appear before Judge Washington, but I'll talk to her and I'll just handle this next stage for you, okay? So that you're not panicking about it. I don't think she'll have a problem with that.
Okay.
Okay? And
Okay.
When's the next?
I'll set your, you're gonna have to come to my probation department at 14A. Okay?
Okay.
And then I'll set her sentencing to February 25th, 2026 at 12 noon. Okay, you'll probably